Good afternoon. Well, through the afternoon for the first time, the Senzo Meyiwa murder trial, after adjourning today, heard from the states. The court deliberated on the state's application to have several media houses, including Newzroom Afrika, banned from broadcasting the trial. The state slammed journalists for what it says is the harassment of its third witness, who took to the stand. Eventually, the court allowed a broadcast of proceedings, but without showing the face of the witness, Mpumelelo Zikalala. I'm joined now by the legal expert, Mpumelelo Zikalala. He is an attorney. He joins us now. Mpumelelo, good afternoon to you. A very strange set of circumstances, a difficult time for the witness, I suspect, almost being chased through the halls by journalists today. In the end, the media, three news organizations, including ours, told to stay out and then finally allowed back in. Do you think the judge was right to, what's the phrase, punish the journalists who he believes misbehaved?
I think, yes, you can punish the journalists in the individuals, but not the media houses. At the end of the day, a person is there fully employed, and they're supposed to act in a manner in which they're going to protect the interest of the particular media house in which they are coming to. Now, to then punish other members of the public from having access to these particular proceedings is, for me, a bit pushing it, which is why I think then the court then said, okay, I'm going to allow the cameras to come in. However, I'm going to take precautions and make sure that the face of the witness is not being shown, which is important, by the way, because we must remember, even though we do have media freedom, it must start and end somewhere. And it's going to end in a particular place where we are then infringing on the rights of a certain individual. And it's going to end when you're about to perform what we call a common law crime called defeating the ends of obstructing the ends of justice, in which if you are going to engage in that particular conduct, while a person is still going to come in and provide evidence to a certain court, you do tend to scare them a bit, throw them off guard, and it's not in the interest of justice that they have been handled in the manner in which they were in, especially when you are still going to get the news while the court proceedings have started. So I think the judge was correct to say, I'm going to take precautions and protect this witness. We need to get down to the truth, and if it means that I have to pass on stringent rules to allow him to have access to this court and to present his evidence, or out of the protection that his face won't be shown, I'm going to do exactly that.
For the fact that he's giving evidence and it's via an audio link and his face is not shown, does that have any impact on any legal impact on the evidence that he gives?
Not at all, because where it matters is with the legal practitioners which are in court. Those are the ones that will be able to determine the demeanor, maybe the way in which he was standing, the way in which he was avoiding answering certain questions, the way in which his eyes are moving, for example. So that's the demeanor which is being looked at by the court. But most importantly, that matters a lot within the legal practitioners and also the presiding officers. So to us, as members of the public, yes, it would have been beneficial for us to have a look at him and be able to see as part of the content which is being shown to us. But where it matters the most at the court, they are getting full benefit of those particular visuals, and it's going to assist them in coming to a determination of whether we're speaking the truth or not.
In the last 10 years, media access to courts has changed dramatically. It was back in 2004, I think, when a judgment was read on TV for the first time, 2005, in the Shabir Sheikh trial. And that, at the time, was very surprising. We've seen a process where the media has been getting more and more access. Do you think maybe for the first time, judges are looking at the way the media is behaving and pushing back very, very slightly, just beginning to set a few boundaries like any good parents?
I think that there need to be boundaries which are going to be there. You can't operate in a space where there are no rules, but the rules are created for a simple intention of saying that I want the evidence which is going to be presented to be heard by me, and by me I mean the judge of the court first, before it is dealt out in the media. And I don't want it to be discussed up until I've completed this particular case, just in case that particular witness is going to come back or be recalled at a later stage. We don't want a witness to go and give out media interviews and then at a later stage be recalled to give evidence which is going to be in conflict with what was stated earlier. So even though you do have media freedom, even though you do have public access to our courts, which is something which is guaranteed in the Constitution, and it has been done a number of times, I can walk into any court, be able to sit and listen to what they are saying, without being asked any questions, unless if the accused is under the age of 18. So if that can be done in a normal court, that can also be expanded in the media discourse that we're in, and also embrace the latest technology that we have. But we must have rules. Those rules saying that let's protect the integrity of these proceedings by making sure that whatever has been said is said first inside the proceedings, inside the four walls of the protection of the law, before it is then discussed out there in the media.
Mpumelelo Zikalala is the person giving evidence now, and it's the first time we've actually heard under oath evidence from what happened inside the house from someone who was actually there. So not a police officer, not an official after the fact, someone who was actually there. That, I presume, gives his evidence quite a lot of power, quite a lot of, legal weight.
You're correct. Let's remember the expert witnesses that came earlier are simply there to give independent advice, which is evidence, which is meant to corroborate the evidence which is going to be stated in by these witnesses that actually experienced this particular crime taking place. So they are better placed because they are the ones who are going to say the perpetrator was sitting or was standing in that particular direction facing me. These are the words that they uttered. This is the manner in which they conduct themselves. So that is direct evidence. You should then be able to pull in whoever is the person that needs to account at the end of the day. So their evidence is crucial. Their instances or ability to remember these particular instances is again very important. And I think that's where the cast of cross-examination is going to come in terms of with the one question which I think will cross-examination will end without it being asked is, did you see any of the people who are sitting in the witness box on the day? Can you be able to point them out today? Have you ever attended an identity parade, for example? And are you seeing them for the first time here in court? It's going to be very crucial. And if the answer to that is that I'm seeing them for the very first time in court, then the focus is going to be on the investigation side. Have the police conducted their investigation in a proper manner, or are there certain flaws that can be picked up for that particular investigation?
You make a very important point that actually, it's usually quite a dramatic moment. Maybe I've watched too much, too many of these legal dramas, but there is that moment where you need to be able to actually identify the person who's accused of the crime if you're a witness. It's absolutely vital. Without that, there's no case, really.
Definitely, especially in instances where there is no other external forensic evidence like your fingerprints or DNA, which is going to link you or place you in that particular place and time on that date. So you need this visual confirmation that, yes, this accused is the one that was on the day, standing there and pointing me with the gun. If you don't have that, the level and the quality of evidence in which you're supposed to bring is going to be a bit weak and may not be accepted by the court. So we stand to hear maybe in the next few days whether those type of confirmations are going to be there. And another important part, when did you go and identify this particular individual? Is it after 2 years, after 3 years, or 8 years down the line? The longer time in which you've stated, or maybe you've been obtained to do that particular exercise, let's remember the quality and the quantity of the evidence doing this. We get old, we forget, and sometimes we do make mistakes. And people, when they are sitting there and are being told that those particular individuals, in one of them, there's one actually a perpetrator, it's very easy to make mistakes or to pin it and say, this is actually the individual that was there when it wasn't.
If we hear evidence from one person who was in the house that night, would you expect that all the people who were in the house that night will have to testify?
I would say yes, but also depending on the value in which they then bring to the quality of or to the evidence that there is. The evidence should collaborate each other to a certain level of extent. I don't expect it to be more or less similar to the T. At the end of the day, we don't see things the same way. And the way in which we remember things is definitely not the same. But the inconsistencies can't be glaring. The inconsistencies can't be things which are so far apart that you can't compliment that a person would make that particular mistake. So it's all up to the stage to make sure that they pierce up their legal strategy to ensure that the witnesses who are going to go in are going to collaborate or be able to collaborate each other. Remember now, there's that issue of the second docket in which there will be various statements which are going to be there. So the witnesses are testifying probably within the third version of the evidence. The first one on the current docket in which is in front of the court. Secondly, on the witness or the evidence that you provide at the court during these live proceedings. And lastly, on the statements in which they may have written when they were doing or during the construction of the second docket. And all these three versions have got to speak to each other. If there's any inconsistency in any of them, then you must be able to explain why that is. And it may be purely by human nature, but if it is glaring an insinuation can be made that they are not telling the truth and they are misleading the court.
So I'm glad you brought up the second docket, because I was trying very hard to be the good journalist and wait for a while before I brought it up. Because it would seem to me that if all of these people have to testify, and if I were the defense advocate, I would call them all just to try and show up and push for inconsistencies, even if they don't really exist. When it comes to the cross-examination, they may find themselves in a position where the defense advocate tries to turn them into the accused.
Definitely. And they would be prepared to answer to those questions. The truth will always come out, and it's not going to change regardless of whatever time you are speaking in, whether you speak it a few minutes after the event or a year or 8 years after. And you have to be consistent in the way in which you state it. And in instances when you have made a mistake, no matter how minor or major it is, you must tell the truth and say, I made a mistake in terms of determining this particular fact. At the time of drafting the statements, I was not within the state of mind that I'm in today. I have a much more clearer mind, or I had a much more clearer mind at the time of drafting this particular statement. But it would have mattered a lot from the side of the NPA when they were preparing a strategy for this case. Remember, as the National Protocol, let's start with the law enforcement agencies. You have a bunch of statements which are in front of you, and you have a duty of saying, do they collaborate each other in instances where they are not speaking with each other or collaborating? Is there an instance of honest people making honest mistakes, or is someone trying to mislead my evidence or mislead me to determine something which is not there? That's important, because obstructing the ends of justice is a crime. And that's exactly what they are doing. They are concealing evidence which have ended up with the convicted people who are guilty of doing this horrendous crime. So at the end of the day, that level of assessment starts within law enforcement agencies and also within the NPA, which is why it's quite surprising why the NPA would keep quiet about the second docket, not say anything about it, or even not disclose it at the appropriate time to the various parties that are there. Even if after it is disclosed, they then say, no, we're still proceeding with the strategy that we have, not having maybe given the assurance that they've looked at it, see whether it collaborates or not, and then take it on from there. But we can't cast aspersions of them. We have to give them the benefit of the doubt that they would have done a proper job in preparing for this matter, and they are ready for any eventuality that they can come at a later stage, pertaining actually to the statements which can be obtained from the second docket.
Mpumelelo Zikalala, a lot more to come in this case. Thank you very much indeed. Really do appreciate it. You expect that testimony to resume tomorrow morning.